Well, on Thursday, a full bench of the High Court in Johannesburg heard the president's urgent request for an interdict against his predecessor, Jacob Zuma's private prosecution case against him. Lawyers for President Cyril Ramaphosa have argued that if his bid for an urgent interdict fails, he'll be subjected to the ANC's step-aside rule. The president will find out on Monday morning whether he has persuaded a court to grant him an interim interdict that would prevent him from appearing before court on January 19th. To discuss this bit and more, I'm joined by legal expert Dr Felix Dube. Dr. Dube, thank you so much for your time and thank you for joining us this morning. As a starting point, I'd really like to hear your thoughts on the sort of legal wrangling that we saw taking place in court on Thursday.
Good morning, Dogozo and the viewers, and thank you so much for the invitation. Well, this continues to be a very dramatic and yet complicated case for various reasons. So what we saw being argued last week was part A of what the president calls his application. So first, he is asking the court to grant him an urgent interdict that is actually going to freeze this prosecution, and then that he also be excused from appearing in court on the 19th of January, which will be this week. So what we see now is the argument from the former president's lawyers saying, but no, there is no agency here, first of all. And secondly, we don't see this motion court, which is an agent court, having powers or jurisdiction over a criminal matter. It has to be brought to the criminal matter. If the president has got anything to argue, he must argue that in the criminal court. And he cannot be, they further say that he cannot be excused from appearing in court. And I think I will understand that to say that if a person is being charged, that person has to appear in court. The judge needs to see the person that is being tried so that it doesn't appear to be a trial in absentia, something which is not permitted by the Constitution. And furthermore, the other question was, can the president actually stop this process? Can this court actually order that process to be frozen? So this was what was being argued in part A of this application. So we expect that judgment to come early next week, and we're going to see if the president has actually won on this one. But I think whichever way it goes, it will have profound ramifications for the rule of law in this country, and it will set a precedent on how similar matters will be handled, particularly because we're seeing more and more of these private prosecutions popping up in South Africa.
Right. On the issue of the president's appearance before court on January 19th, former President Jacob Zuma's lawyers, accused the president of arrogance in this regard, almost suggesting that appearing before court is something that he has deemed beneath him as, the number one citizen in the republic. What do you make of that argument? Because for others, it may seem that the president is simply utilizing whatever legal resources are available to him to disabuse the former president of the sort of private prosecution processes that he's launched against him.
I would say that litigants in any court of law will always try to find loopholes in the law. They'll always find some clever tricks to avoid certain things. But in this case, I think the president and probably the court also, they're sort of like in a bind because, as I said, you cannot be excused from appearing in a criminal matter, particularly in proceedings in which the charges will be formally brought to you in a court of law. It all goes back to the question of equality. How equal are we before the law? Can I tomorrow be charged with a certain offense and then I be excused from appearing in those proceedings? And I think also the arrogance argument stems from the fact that, you'll recall that when the summons and the indictment were delivered to the president, there was sort of like a communication from his office that these summons were such an abuse of court process that they deserved to be ignored and that they do not need to be honored. They are just nothing. But then that argument is sort of like softened. That's why we see the president going back into court. The reason being, if you are to ignore those summons or not to appear, then what does it say about the other litigants who tomorrow may be charged? Are they also entitled to disregard those summons and an indictment if they feel that the court process is being abused? So this is much bigger than the president, but it is about how the rule of law will work going forward in South Africa.
On the issue of the rule of law, sort of the trump card that was raised by President Cyril Ramaphosa's legal team was the fact that, should this private prosecution move forward, he, of course, would be then subject to the ANC's step-aside rule. So in essence, the president bringing his sort of own political dilemmas into this litigious matter. What do you make of that particular argument? Is it something that the court should indeed entertain, given the fact that if indeed he does have to step aside, it will have profound consequences constitutionally and just in terms of the rule of law?
I will say that politically this is a good argument. He has a good argument on the political side because it will really have serious implications. I don't know if it will really have any serious implications. I mean, we saw what happened with the parliamentary report. People thought it would have serious consequences, but now it is all in the dust. What I will say about that argument in the court, I don't think it is a legal argument. I don't think it is an argument that the court should actually consider having to suffer prejudice, personal prejudice or political prejudice as a result of a prosecution is in itself not a legal argument. Look at it this way. If someone if somebody else, not the president, who is a politician, is about to be charged, can they actually really run to court and say, look, set aside this summons, excuse me from appearing because, well, I'm going to lose my political career? It's not going to be allowed. We have seen with the Esma Hashile cases, he has lost all the way to the highest court because they've said, no, you need to step aside if he has been accused of corruption. So right now, that's why he's out totally now.
Yeah. Another issue that was sort of up for discussion within that courtroom is whether or not the National Prosecuting Authority has explicitly clarified if this private prosecution can move forward on legal grounds, as in that certificate wasn't necessarily issued to say that as the National Prosecuting Authority, we have, satisfied ourselves in looking into the issue and have declined to prosecute, and in so doing, have opened up the doors to allow a citizen to follow through with a private prosecution. Is that sort of open-ended issue likely to be properly entertained by the court in this regard, or has the horse sort of bolted from the stable at this point?
I'm of the view that the NPA shouldn't be having a role in this case because they have already issued a certificate, and that certificate is worded in a very clear manner. They say, we have looked at the affidavits, we have looked at all the issues pertaining to this case, and we decline to prosecute any person connected with this thing. And the term any person is the same term that is used in the Criminal Procedure Act in the section that deals with this private prosecution. So it says the NPA may refuse to prosecute any person and may issue a certificate in that regard. I have looked everywhere in the law. I haven't seen a specific provision that says you must name the particular person by name and surname. It just says any person. I haven't seen where it says you must explicitly identify the person. It might as well be that it is the usual practice that they will identify the persons whom they decline to prosecute. But as far as I have read the law, there is no provision that they really actually are obligated to identify the particular person.
Right. And I mean, just, at the heart of this, of course, is the urgency of it all. I mean, do you think the president's lawyers were able to, fully prove before the court that this matter is urgent and as such needs to be entertained as an urgent interdict?
I'm of the view that it is respectful, so it is not, there is no urgency here. Perhaps the urgency will be the disastrous public relations outcomes of his appearance in court. I mean, we saw with Mr. Downer appearing with Ms. Carmon, We saw the pictures there. They looked very pitiful. So there will be probably people who would want to see the president appear in the dock, and they will take those pictures and videos, and they will sort of like make these memes and all sorts of things. So on a public relations angle, it is a disaster. But legally, I don't see the urgency of it. I mean, the 19th is here. If there are any issues that need to be raised, they have to be raised in the criminal court, not in this urgent court. Because we have seen with those 4 Zuma cases, the court said, if you have any problem with anything, you don't raise it with the court. You need to raise it in the criminal court, not in any other court. So I don't think there is urgency on this issue.
All right, well, Felix, we'll leave it there for now. That's a legal expert, Dr Felix Dube, helping us to make sense of that legal showdown that took place in the Johannesburg High Court on Thursday. President Cyril Ramaphosa, of course, trying to interdict that private prosecution against him, which